Hello, everyone, and welcome to Jamaica Data Protection Act and how to best prepare for it. I'm your host, Wilfredo LaSalle, CEO of Simplex. Simplex is a cybersecurity software as a service product that can help you get compliant, simple, and easy. So today's webinar will be on Jamaica Data Protection Act. Join us for this insightful webinar featuring myself. In this comprehensive session, we will delve into the crucial aspects of the Jamaica Data Protection Act, equipping you with the knowledge and tools necessary to navigate its requirements successfully. So let's begin. Here's the outline and agenda for today's meeting. We'll have an introduction, the objectives of the Data Protection Act, defining the terms, data protection standards, transitional provisions, data breaches, and the summary of points moving towards compliance, especially utilizing Simplex as the tool behind that. The right to privacy is universally considered an inalienable human right, established as such by the United Nations in 1948 Declaration of Human Rights. But I wonder if those wise writers had any notion of the kind of privacy issues people would be facing over 70 years later. Could any of them imagine a world where we can announce in a way that is almost globally accessible the most minute details of our daily routines? Did they realize there would come a time when impossibly sophisticated machines could calculate whether we looked at one advertisement longer than we looked at another? Did they know that we would need to expand the definition of personal information from the broad strokes of name, address, identification number, and telephone number to include details like the sequence of our DNA or a record of everywhere we have driven in a day's time? And did they know that in 2023, personal data would be one of the most, if not the most, valuable commodities on Earth? Data is the new oil after all. Forgive me for sounding dramatic, but what I say is not hyperbole. And let's also forgive those original writers who at the time defined the right to privacy saying, "No one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attacks on his honor and reputation." If they could only see us now, I'm not sure if they'd laugh or cry at our predicament. On one hand, we are remarkably cavalier about handing our private information over to just about anyone who asks for it. And on the other, many of us are quite ready to use the personal information of others to improve the functioning of our businesses. We think, where's the harm in it? That question, unfortunately, is where we fall down. We don't generally recognize the harm in it until the harm has been done. Perhaps that is why it is so difficult for governments to catch up with protecting us from ourselves. Most of us were giving our lives away, and conversely, taking advantage of that fact about others long before anyone recognized this could be a problem. And recognizing the problem was only the first step. After that, we had to figure out what to do about it and create the legislation to enforce those decisions. Businesses' treatment of personal data continues to undergo changes. This information age forces countries worldwide to recognize individual rights about personal data. In 2011, the Jamaican Constitution was amended with a new Charter of Fundamental Rights and Freedoms, giving its citizens the same legal protection enjoyed by those of other countries: respect for and protection of private and family life and privacy of the home, and protection of privacy of other property and of communication. However, constitutionally declaring the right does not adequately safeguard it. Jamaica has taken a significant step in the direction by passing of the Data Protection Act. Data protection, remember, ensures the safety of an individual's personal data as it is being used or handled by other entities. The objectives of the Data Protection Act. The Act's objectives were to define the principles for the treatment of personal data and provide for transparent oversight, enabling the public and private sectors to strengthen the protection of personal data. Jamaica created data protection legislation for several reasons. Here's three. One, there are increasing technological advancements that permit data to be processed, stored, and distributed. Two, there is increasing electronic commerce. COVID-19 put all businesses into unexpected new circumstances. The pandemic accelerated online business and remote work. The protection of data goes hand in hand with these changes. Three, there are obligations imposed by trade agreements that such protections be in place, If Jamaica wishes to continue doing business with countries where protective legislation exists, it must employ sufficient measures to meet their standards. The Data Protection Act represents a fundamental change in the way data is to be handled going forward by imposing certain obligations and guidelines regarding processing, storage, use, and disclosure of personal data for the following groups: 1. Data controllers, 2. Data processors, and 3. Data subjects. The Act has huge implications for the people and businesses of Jamaica. Compliance will be a requirement as of December 1st, 2023. Keep that in mind, guys. Any organization that waits until the last minute to get its house in order is risking a great deal, as the penalties for non-compliance are not only painfully expensive, but downright serious, including the possible incarceration of responsible organization officers. Fear not. That is why we're here today. In this presentation, we'll go through the DPA step by step so that you have a solid understanding of what is required of you and your organization to be timely compliant with this important act. Defining DPA terms. The first thing you must establish for your organization's sake is what role or roles your organization holds. Who are data collectors? Data controllers, rather, sorry. Data controllers are companies, public authorities, or persons who decide how personal data will be processed. Who are established in Jamaica or anywhere that Jamaican law is applicable by virtue of international public law, or who, although not established in Jamaica, use equipment located in the island for the processing of personal data, otherwise than for transit throughout Jamaica, or processes personal data of an individual in Jamaica, and the processing activities are related to the offering of goods or services to individuals in Jamaica, regardless of whether a fee is required, or related to the monitoring of the behavior of individuals insofar as their behavior takes place within Jamaica. Just because you are not a credit card company or a hospital, don't assume that you're not processing personal data. In fact, due to the broad definition of both personal data and processing, it may be difficult to find a business out there that isn't a data controller in some capacity. It applies to brick and mortar stores, as well as businesses conducted entirely online. If you are an employer gathering personal information for your employees for payroll, you are a data controller. That means that the donut shop where you buy your morning coffee is probably a data controller. If you have personal information about your clients or customers for the past 20 years locked in a file cabinet in your office, you are a data controller. Even if that data never goes into an electronic database, you are a data controller. Obligations for data controllers. Point 1. Data controllers must be registered with the Information Commission, agreeing to comply with the standards in the legislation. That is the authority established by the DPA to oversee compliance with the Act. Point 2. In certain circumstances, the appointment of data protection officers are required, such as when the data controller is a public authority, when the data process is sensitive, and where the data controller's processes on a large scale. Point 3. The data controller must comply with all 8 standards of the DPA. Failure to do so could result in sanctions. Point 4. Data controllers have a 2-year transition period from the appointed date to take the steps needed to be in full compliance with the Act's requirements. Consequences for breaching the standards, which, guys, we don't want you guys to do, and that's why we're here today to inform you. I bring this up early in this webinar presentation to emphasize the importance of knowledge and compliance with the 8 standards of the DPA. If a data controller is not registered with the Information Commissioner, but processes personal data, the penalty is up to $2 million or 6 months in prison. A data controller who does not comply with the standards may face a fine of up to $2 million or 7 years in prison. If a company breaches the DPA, they are liable to a fine not exceeding 4% of the annual gross worldwide turnover of the company. That's huge, guys. Officers of the data controller are also liable. In the event of their consent to a breach, or if a breach is attributable to the neglect of any officer, that officer shall be liable as well as the body corporate. And don't forget, if a data subject is aggrieved by a breach by the company, they may bring a civil claim against the data controller, above and beyond the penalties from the Information Commission. Who are data processors? Data processors are not employees of the data controller, but may process data for the data controller. Examples include outside companies that work in conjunction with your company, such as website hosts, IT companies, delivery services, temp agencies, or marketing companies that have access to your company's data. Who are data subjects? Data subjects are the individuals that are the subject of the data collected, whether they are identified by name or number or other means. Under the DPA, individuals have the right to know what data is being collected by companies and to understand what it is being used for. What is processing data? Processing data has a broad definition under the DPA. It includes obtaining data, recording/storing the data, carrying out any operation or set of operations on the information or data, such as organization, adaptation, or alteration of data, retrieving, consulting, or using of data, disclosing the data by transmission, dissemination, or otherwise making it available, aligning, combining, blocking, erasing, or destroying the data, or rendering it anonymous. Considering this extremely wide scope, it is vital that data controllers and data processors be aware that their actions are almost inevitably covered under the DPA, and they can be severely penalized under the sections regarding processing data if they are not compliant with the standards set forth therein. What is personal data? Personal data is information relating to a living individual or to a person deceased for less than 30 years. Sensitive personal data. Sensitive personal data is a subset of data that includes biometric or generic data. I'm going to go a little deeper here because this is an extremely touchy category. Depending on how you look at it, our ability to collect biometric data on individuals is either amazing or alarming, maybe both. Biometric data includes any information relating to the physical, physiological, or behavioral characteristics of that individual, which allows for the unique identification of the individual, including physical characteristics. It's important to note that this includes things like photographs, signatures, voices, and fingerprints. Trade union membership, sex life, physical or mental health, racial, filial, and social identifications, political opinions, philosophical or religious beliefs, alleged commission of offenses, or proceedings for offenses. Sensitive personal information is held to higher and more standards for protection, and with good reason. If you are a data controller holding sensitive personal information, your audits and self-monitoring should be meticulous. Now, remember when I said that keeping information on your employees made you a data controller? Take a moment to consider how much of that information falls into the category of sensitive personal data. When consent isn't enough. In a moment, we'll begin our discussion of the 8 standards of data protection, which includes the fair and lawful consent of the data subject for their personal data to be used. Just remember that when dealing with the processing of sensitive personal data, consent is a get-out-of-jail-free card. It's not a get-out-of-jail-free card, I'm sorry. And data subject consent does not mean you are off the hook if you fail to meet the standards. Regardless of whether consent of the data subject has been attained, the commissioner may specify circumstances in which the conditions identified as necessary to the processing of personal data have not been met. For the avoidance of doubt, a data subject may at any time withdraw consent to the processing of any sensitive personal data in respect of that data subject. Exceptions to the rules. Some data is exempt to the standards and disclosure requirements in the DPA. Preservation of data that is in the interest of national security, investigation of crime or assessment of tax, discharge or any function by a regulator, information that the data controller is obliged to make available to the public under any enactment, data required for the purpose of avoiding an infringement of the privileges of either House of Parliament. If you aren't certain whether your data processing is exempt, seek the advice of your legal counsel rather than hoping for the best. Data protection standards. There are 8 standards created by sections 22-31 of the DPA with which data controllers must comply, and it is essential that data controllers understand what each of these standards mean. The Act imposes the obligation for compliance with data controllers. Data controllers must focus on these 8 standards for all the data under their control. Processing personal data in contravention of any of the 8 standards is an offense. Any contravention of the standards or security breach that affects personal data must be reported to the Information Commission. Affected data subjects must be notified within 72 hours. Failure to report or notify is also an offense. Now, we'll break down the 8 standards so we have a good understanding of what each one means. Standard 1, fairness and lawfulness. The fair and lawful obtaining of data has several important components, so let's look at each one. Personal data must be processed fairly and lawfully and must not be obtained by deception or any misleading information. First, what do fairly and lawfully mean? Fairly means the data is obtained legitimately, and that the data subject is informed and is aware that their data is being processed. Subjects can't be deceived or misled as to the purposes for which they are to be processed. But additionally, data is not considered to be fairly procured unless 1. It is obtained directly from the data subject or person authorized in writing by the data subject or the commissioner to provide it. 2. Data controller ensures data subject is provided with certain information, including data controller's identity, purposes for which the data will be processed, identity of third party to whom disclosure is contemplated, expected period of retention of the personal data. Lawfully means there is a legal basis for the processing. There are 7 conditions for lawful processing of personal data. 1. Data subject consents. 2. Data subject has published the personal data. It is on social media, and isn't it surprising how many of us blithely publish our sensitive personal data across multiple platforms? Just remember, if you posted it on Twitter, you can't complain when somebody uses it to target advertisements to you. 3. Processing is necessary for performance of data subject's contract, such as the purchase of land. 4. Processing is necessary for compliance to data subject's legal obligations, taxes. Processing is necessary to protect data subjects' vital interests. In medical situations, for example, your personal data is essential. 6. Processing is necessary for the administration of justice or carrying out legislative or public functions. 7. Processing is necessary for purposes to pursuing the legitimate interests of data controller or third party. If you are processing sensitive personal data, there are different standards for whether that data is lawfully gathered. If you are dealing with sensitive information, it is vital that you acquaint yourself with these 11 conditions. The conditions are similar to the conditions for processing personal data, but are more specific as to circumstances and make more stringent demands on the data controller. Standard 2, purpose limitation. Personal data must only be obtained for a specific and lawful purpose and must not be processed in any manner incompatible with those purposes. Purpose limitation ensures that data is not processed beyond what has been lawfully declared. This information is divulged to the data subject in the privacy notice, or terms and conditions, or consent forms, in clear and unambiguous language telling the data subject, we will use this information for this purpose. Then all processing done afterwards must be within the bounds of that description. Personal data cannot be obtained for illegal or immoral purposes. This standard means data controllers are prohibited from collecting personal data to provide a specific service, then disclosing or selling the data to a third party for direct marketing purposes without obtaining the data subject's consent. Suppose I submit my waist measurement to buy that pair of pants that will fit me. But let's say the clothing company has an algorithm that notices my weight measurement is quite a bit higher than average. If they sell my information to a fitness company so that targeted weight loss and exercise ads can be sent to me, they have breached the purpose limitation. Direct marketing. Because it is directly addressed in this standard, let's take a closer look at direct marketing, which is prohibited under Section 10, except where done in accordance with the Act. Direct marketing means approaching a data subject in person or by any other means, direct mail, web marketing, text messages, emails, sponsored ads through social media platforms, for the direct or indirect purpose of A, promoting or offering to supply goods or services, or B, requesting a donation of any kind for any reason. The DPA does not seek to stop direct marketing, but instead creates focus for companies to understand how they retrieve data. Data subjects must consent to direct marketing. Data controllers shall not process personal data for the purpose of direct marketing without the consent of the data subject. Consent. Under the DPA, consent is any informed, specific, unequivocal, freely given expression of will, where an individual agrees to the processing of their personal data. Among these requirements, let's define 2 key concepts of consent. Informed and freely given. Informed. At the time the individual consents to direct marketing, they'll be told how the data will be processed, the purpose for which it will be processed, and the class of persons to whom it will be transferred. Freely given. Consent is not freely given if that consent is required for them to receive goods or services from a company. That is, you cannot hold goods or services for ransom in exchange for personal data unless that data is truly necessary under the circumstances. Necessary data might be divulging your waistline measurement if you want to buy a pair of pants. That is a reasonable request. However, knowing your date of birth for such a purpose would not be necessary. An individual may withdraw consent to process into direct marketing at any time, in the same form in which it was given. Businesses need to assess their direct marketing practices to ensure that they will comply with this standard. Standard 3, data minimization. Personal data must be adequate, relevant, and must only be limited to the purpose for which it is being processed. Data controllers shouldn't hold more data than is strictly required for their purposes. Businesses seem to like to ask for as much information as they can get. Once people start filling out a form, why not ask them for everything? You never know when that information might come in handy. Strike a balance. You must get enough data to ensure your outcomes, but only that much. Many firms will need to review the current information forms they use because they ask for irrelevant and excessive information. Under the DPA, processing excessive data may be considered an invasion of privacy. Standard 4, accuracy. Personal data must be accurate and, where necessary, kept up to date. This standard ensures that automated decisions are based on accurate data and that information is mailed, emailed, or directed to the correct data subject. Companies have been sued for sending personal information to incorrect or old addresses, resulting in a breach of the 4 standard. Organizations must check with their data subjects periodically to be certain that their information is current. You may have periodically received emails or correspondence from financial institutions, for example, asking that you check and confirm the accuracy of your contact information. Data controllers who must maintain this up-to-date and accurate data should keep a precise record of any such reasonable attempts made to do so. For example, at any point your organization requests data confirmation from its customers, don't just keep track of the responses, but also of the ones who did not respond. Companies are not in breach if the inaccurate data is provided by the data subject or a third-party company. There is a specific provision that says if the data controller can demonstrate the information it acted on was information provided by the subject and the data controller acted reasonably, the mistake is not the data controller's fault. The data subject still has a certain responsibility to keep their data current. However, the DPA expects data controllers to take reasonable steps in verifying data accuracy. Standard 5, storage limitation. Personal data must not be kept for longer than is necessary and must be disposed of in accordance with any regulations once passed under the Act. Remember, the definition of data processing includes storage. Just having the information and not using it still amounts to processing until that data is deleted. This standard is perhaps the most unpredictable of them all because regulations have not yet been established, and the length of time required for data storage will vary across industries. If you have no regulations guiding your actions in storage limitation, you can usually turn to the common sense for your answer. Some basic rules of thumb are, if you do not need the data, get rid of it. Once you have used data and are finished, get rid of it. Wherever possible, delete and destroy personal data immediately after processing. As a practical matter, if your organization collected data before the introduction of the DPA and you didn't get this data in compliance with this new act, then as part of protocols going forward, it would be wise to contact subjects and ask them to opt in and give their consent. Ensure going forward that from that date, you can be defended on the basis of new standards. Personal data must be processed in accordance with the data subject's rights. These rights are important to individuals, the data subjects, and organizations, the data controllers and data processors. Data subjects' rights are found in sections 5-13 of the DPA. Become familiar with them. Data processing in offense of these rights is a breach. Data subjects' rights are as follows. 1. To be informed whether their personal data is being processed for a data controller, where it is held, where it came from, where is the data being processed by a machine or an algorithm. 2. 2, a description of the personal data that is being processed. 3, to be provided with the information constituting the personal data of which the individual is the data subject and any information available to the data controller as to the source of the personal data. 4, to have the personal data transmitted to another data controller. 5, to be informed by the data controller of the logic involved in the decision making. For example, if a credit check results in an individual being denied a loan, that individual has the right to ask on what basis that decision was made. 6, to prevent processing of personal data where A, such processing is likely to cause substantial and unwarranted damage or distress. B, the personal data is incomplete or irrelevant with regarding to the purpose of the processing. C, the process of the personal data is prohibited under any law. And the personal data has been retained by the data controller, then it may be retained under any law. The right to request the data controller rectifies inaccuracies to any personal data. 7, the right to request that the data controller rectifies inaccuracies to any personal data. Remember that once an individual requests that their data not be processed, the data controller is obligated to undergo its own internal process to ensure that this right is not infringed. Data controllers who receive notice to cease and not begin processing must give effect to the same within 21 days of receiving the notice and provide a written statement of the action taken. Individuals also have the right to their personal data. They can make a written request to a data controller to be informed whether his or her data is being processed, to what purpose, and to whom it has been sent, for a fee to receive an intelligible copy of the related data, for a fee and when feasible, to have the data transmitted to another data controller as specified. This is known as the right of data portability. The data controller is required to comply with an access request promptly, but no later than 30 days, or such longer maximum period as may be prescribed. When can a data controller refuse to comply with such a request? 1, when they aren't satisfied of the identity of the individual making the request. 2, when disclosing information might disclose another person's information and consent has not been given. 3, when the request is identical to a previous request without sufficient elapsed time. 4, when disclosure would constitute disclosing a trade secret. Standard 7, implementation of technical and organizational measures. Personal data must be protected using appropriate technical and organizational measures so as to prevent unauthorized or unlawful processing of the data, as well as any accidental loss or destruction of or damage to the data. A data controller is obligated to take any measures necessary to ensure their adherence to the DPA requirements. When a data breach occurs at a business, the first question asked in the resulting investigation is whether that business took the necessary measures to ensure the protection of the data. If it is shown that they did not, they are liable for the fines and possible imprisonment of the culpable officers, as well as civil lawsuits. Some of these technical and organizational measures would include conducting security audits, testing the effectiveness of existing technical and organizational measures, implementing data protection policies and privacy notices, backup and restoration systems, protection of confidentiality, integrity, availability, and resilience of processing systems and services, proper training of employees on the handling, storage, and disclosure of personal data, pseudonymization and encryption of the data, limiting employees' access to the data, ensuring that any data processing software and antivirus software used by the company are effectively maintained and up to date, selecting data processors who sufficiently guarantee that they have adequate security measures in place and will report security breaches, sufficient guarantees from third-party processors of their technical and organizational security measures, and that they have taken reasonable steps for compliance. You cannot pass the blame to a third-party processor if the breach has occurred under your watch and you did not have sufficient guarantees from them. Written contracts with third-party data processors stating that they only act on the data controller's instructions, the ability to restore the availability of and access to personal data in a timely manner in the event of a physical or technical incident. Standard 8, cross-border transfers. Personal data must not be transferred to a state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection for the rights and freedoms of the data subjects in relation to the processing of personal data. The Information Commission determines an adequate level of protection by examining the nature of the data, the state or territory of final destination, the laws of the state or territory, the international obligations of the state or territory, and the security measures taken by the state or territory. There are certain limitations on the standards, such as when a data subject consents to such a transfer, or the transfer itself is necessary for the public interest or the performance of a contract. Transitional provision. Transitional provisions. These are a pair of provisions that are highly relevant to data controllers, as this Act moves towards its deadline for compliance. Section 76 of the Act says that 1. A data controller shall take all necessary measures to ensure its compliance with the provisions of this Act, and in particular the data protection standards, on or before the expiration of a period of 2 years from the earliest day appointed under Section 1(1). This means from the date that the Act comes into operation, everybody has 2 years to get their house in order. And we should note that complying with the 8 standards is pointed out specifically as the starting place. 2. No proceedings under this Act may be taken against a data controller in respect of any processing of personal data, done in good faith during the period referred to in Subjection 1. However, even before the 2-year period ends, if the Information Commission discovers a data controller processed personal data in bad faith, it may also face penalties. This is why it is important not to wait until the drop-dead date to ensure your practices are in line with the standards. 6. Data breaches. If there is a security breach, the Act imposes broad obligations on the data controller's response. The Information Commission and the data subjects must be notified of any breach or contravention of the standards, and this includes breaches that have affected the data, but also those that may affect the data, meaning that even if nothing has happened to the personal data, if the breach presents a potential risk, you've got to let them know. The Information Commissioner must be notified within 72 hours of the company's awareness, and the information included must be the facts surrounding the security breach or contravention, a description of the nature of the security breach or contravention, including the categories, number of data subjects concerned, and the type and number of personal data concerned, the measures taken or proposed to be taken to mitigate or address the possible adverse effects of the breach, the consequences of the breach, and the name, address, and other relevant contact information of the company's data protection officer, if any. Data subjects must also be notified of the nature of the security breach or contravention, the measures taken or proposed to be taken to mitigate or address the possible adverse effects of the breach, and the name, address, and other relevant contact information of the company's data protection officer, if any. Summary of points moving towards compliance. When your organization begins its steps towards compliance with the DPA, there are certain questions to ask. What personal data are we processing and why? This is best answered by conducting a careful audit of all departments. Data controllers should note the following when conducting an audit of your practices. 1. An organization's list of outside data processors can grow exponentially when considering its number of departments, each of which performs multiple tasks, with each such task possibly employing or requiring multiple outside resources. 2. Data processors are often located outside of Jamaica. 3. The DPA's extremely broad definition of processing. 4. The DPA's extremely broad definition of personal data. 5. The special categories of data, including sensitive personal data, which have more stringent standards of protection. Are we complying with each of the 8 standards? Once you determine what data your business processes, go through the 8 standards and determine your compliance. Standard 1, fairness and lawfulness. Your organization should ask, how did we get the data? Did we mislead the subject to get it? Is the subject authorized or required to supply the data? Standard 2, purpose limitation. Your organization should ask, are we engaging in direct marketing or the selling or sharing personal data with other organizations? If so, do we have the consent of our data subjects? Are we following the DPA's definition of consent, which is any informed, specific, unequivocal, freely given expression of will where an individual agrees to the processing of their personal data? Standard 3, minimization. Your organization should ask, are we asking for more information than we need to get the job done? Standard 4, accuracy. Your organization should ask, are we maintaining up-to-date and accurate information from our data subjects? Are we tracking the responses, or lack thereof, of our data subjects when we request updated, accurate information. Standard 5, storage limitation. Your organization should ask, do we still require the data we have collected? How will we determine how long no longer than necessary is? Is our industry subject to regulations on storage limitations? Standard 6, rights of data subjects. Your organization should ask, are we familiar with the data subjects' rights as listed in sections 5 through 13 of the Data Protection Act? Do we have easy and reliable communication with our data subjects? Are our consents, terms, and conditions and other forms up to date and written in clear, unambiguous language? Do we have a method for timely response to requests from our data subjects? Standard 7, implementation of technical and organizational measures. This is the most vital standard for your consideration. In effect, this standard is where the rubber meets the road. All the good intentions in the world will amount to nothing if your organization is not technologically equipped to handle the burden that data controllers must now carry. The burden to protect the confidentiality, integrity, availability, resilience of the data you collect and process. Your organization should ask, are our technical and organizational methods capable of meeting the DPA's requirements? Is our antivirus software effectively maintained and up to date? Do we conduct security audits and tests of our measures? Do we have adequate storage, backup, and restoration systems? Are we properly training our employees and limiting their access to data? Are we taking correct measures to ensure our data processors have adequate security measures in place? Do we have guarantees of their technical and organizational security measures and that they have taken reasonable steps for compliance? Standard 8, cross-border transfers. Your organization should ask, how can we ensure that any cross-border transfers we conduct are to states or territories with an adequate level of protection for the rights and freedoms of our data subjects? If not, what can we do to become compliant? Once your organization has been through these standards and determines how it measures up, the next matter is how to fill in the gaps where your data protection falls short of the mark. Here are some recommended steps for companies to take. This is by no means everything that can be done, but it's a good start. Implement data protection policies accessible to employees and customers. Point 2, ensure encryption and password protection of personal data. Item 3, limit access to personal data. The information should be need to know only. Point 4, require non-disclosure agreements and/or confidentiality agreements of those employees who do not have access to personal data. Step 5, conduct frequent security audits, ensuring compliance with local and national standards of data protection. Step 6, monitor data processing software and antivirus software for assurance that these are maintained and updated regularly. Step 7, obtain the express consent of any employee or customer whose personal data is collected. Do we need to consult legal or technological help to achieve compliance? Absolutely, especially if you need help understanding the legal terminology and implications, as well as finding out the weak spots in your organization's electronic systems. Cybersecurity, even in improving your paradigm about these things. This is not a time to try and do it yourself or cut corners on expenses. Remember, ignoring data protection puts your company at serious risk. This is why Simplex is such a valuable tool, and the platform is such a great tool to help you move towards compliance and also to put you in contact with partners and other vendors that can help you wherever not only are your technological gaps, but your informational gaps, right? Or your understanding and your further understanding of the compliance by talking to legal, technology, and cybersecurity professionals. Conclusion and questions. From the perspective of the data controller, maintaining such standards may feel like carrying the weight of the world. From the perspective of a data subject, however, these protections are a service that shows your organization's concern for their privacy and safety. Most of us here today function in dual roles. We all are data subjects, while also being data controllers or data processors. As such, we easily see both sides of the coin when it comes to this new age of processing personal data, the burden and the benefits. It has been my pleasure to guide you today through steps towards compliance with the DPA. I believe that this act and others like it will continue to evolve as our uses for personal data become ever more varied and unexpected. Thank you.